a case concerning immigrant removal provisions.
Everyone, listen up. Listen up. We've got a decision. We've got a decision.
Where'd they go?
It's in the Supreme Court, the decision's in.
The vote is 6-3.
6-3, we win! We win!
All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention.
Landmark Cases, C-SPAN's special history series, produced in partnership with the National Constitution Center, exploring the human stories and constitutional dramas behind 12 historic Supreme Court decisions.
Mr. Chief Justice, and may it please the Court.
Good evening and welcome to C-SPAN series Landmark Cases. Tonight's case is New York Times Company versus the United States. In this 1971 case, the Supreme Court ruled 6-3 against the Nixon administration in a big win for journalism. The decision upheld the New York Times and the Washington Post, which you just saw depicted in this recent movie, right to publish classified information on the history of the Vietnam War over significant objections from the Pentagon and the White House. We have two terrific guests at the table tonight to help us understand how this case unfolded and what it means for us today in our society. Let me introduce you to Floyd Abrams. He might be the nation's best-known First Amendment lawyer. He was co-counsel in the New York Times case, and he is now an attorney with Cahill Law Firm in New York City, where he does focus on First Amendment and media law, and also is a guest professor at Columbia University's Journalism School. Welcome to our program.
Thank you. Good to be here.
We're pleased to welcome back Ted Olson. Mr. Olson has argued 63 cases in both private practice and for the government before the Supreme Court, including during his term as Solicitor General from 2001 to 2004. One of his key cases representing President Bush and Bush v. Gore. He's also a partner now at Gibson Dunn in Washington, and we are pleased to have you back. You were with us on the first term, and we're glad to have you back for our second season.
I'm delighted that you would ask.
So we're going to start with understanding how broad or narrow this decision was. Help people understand the decision before we go into all of the details. What did the court actually find?
Well, the court found that the Times and the Post could not be restrained in advance from publishing, a prior restraint, as it's known. And they said that it is a very heavy burden that the government has to overcome. They have to show real, irreparable harm to the country, and that the government had failed to do that. So that was the ruling of the court. In addition to that ruling, there were 9 separate opinions by members of the court. And while they all agreed that prior restraints are difficult, very difficult to obtain, the vote in the case was 6-3, as we just heard, in favor of the Times, and the justices ranged considerably in what they said about that, from a very modest victory to a very broad one. But at the end of the day, the ruling was that the government, even during a war, even when there were American prisoners of war held by the enemy during that war, had not shown enough that publication of this historical study of how we became involved in Vietnam would do terrible harm.
Ted Olson, if it is a narrow decision and prior restraint in the First Amendment, what about this case has made it a landmark decision?
Well, this was a very, very big decision. This was the Nixon administration attempting to stop the Washington Post and the New York Times from publishing excerpts of the Pentagon Papers. This was a big, huge study of the origins and the conduct of the Vietnam War. The government was saying it's very important, it's dangerous to our national security if this material is published and made available to the public. And the Supreme Court of the United States, in this 6-3 decision said, no, we will not stop the publication. If it may have violated the law, that's a possibility, and you might want to prosecute people criminally for violating the law if you can prove that, but we will not stop, as Floyd said, in advance, a publication of material that's in the public interest. We won't tell the press under the First Amendment that you can't speak, that you can't publish something.
So just to underscore, they cannot be stopped from publication, but there's no guarantee that there couldn't be sanctions for publication.
That's correct. And indeed, opinions of some of the justices who voted for the Times, Justice White and Justice Stewart in particular, indicated that a criminal prosecution could be brought and might have succeeded. I mean, bear in mind, of course, the case came up very quickly, and the members of the court, as some of them complained, were not deeply enmeshed in the facts of the case. They really left it to the government to persuade them, which the government failed to do, that publication would do great harm. But when you read those opinions, a majority of them thought it would do harm. I think it's worth saying it did not, but a majority of the members of the court thought publication would do harm, and nonetheless that the Times and the Post could publish.
This series is about our Constitution. So at the outset, we always look at the constitutional provision that is under examination in the case. This is a First Amendment case, and the First Amendment reads as such: Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So a question for both of you. Before this 1971 case, there had been some earlier cases. We have a 1931 Neer versus Minnesota, a 64 case, New York Times versus Sullivan. What was the law about how far the press could go in publishing prior to this case?
Well, I'd say the most important case was that 1931 case, and in particular a line in it which, in the course of saying that prior restraints were terribly difficult, almost impossible to be issued by courts, they offered an exception, and the exception was the timing of ships sailing in time of war. So during the case, both sides spent a lot of time arguing about whether this was like a ship sailing in war, or whether publication of this material, of how we got into the war in Vietnam, was akin to the sailing dates of ships during a war. So that 1931 case helped enormously and was by far the closest case, and it wasn't that close, but the closest case there was.
Ted Olson, the Espionage Act of 1917 was the law that the government was looking to in this case, and I'm going to ask what we should know about that law as we think about the questions in the case.
Well, the Espionage Act is a very old statute. It is very unclear as to what it prohibits and under what circumstances it would impose punishment on someone who leaked materials, who communicated information that might do damage to the national security. There was an argument in this case about how far it went. It did not authorize the government to stop publication of a document. It imposed criminal penalties or fines on someone who disclosed national security information. The court specifically pointed out in this case that there was no statute that gave the government the power to ask the courts to stop the publication of materials. This business about prior restraints is very important, because if you stop someone from speaking or stop someone from publishing, it won't happen. There's a lot of things that can be done. You can take some risks by speaking about something. That 1931 case was an attempt to stop the publication of defamatory material. It was an expose by the newspaper, and the statute said, well, you can stop the publication of defamatory or scurrilous material. And the Supreme Court said, no, you can't do that. The principle is that if you stop someone from speaking, it won't be heard. And that's a very, very difficult thing under the First Amendment, which says Congress shall make no law abridging the freedom of the press.
You know, there was a time when the only thing that the Supreme Court said was protected by the First Amendment was against prior restraints. Oliver Wendell Holmes, back in 1905, wrote an opinion saying just that prior restraints are what the First Amendment is all about, and only what the First Amendment is about. Now, we've come a long way since then, but the point is really that what everyone historically has agreed upon most is that the prior restraints, limitations in advance on speech, are the most dangerous, the most limiting, and therefore the most protected against activity of the government.
We're going to move from the constitutional and legal framework for the case into the particulars. Before we do that, let me tell you how you can be involved, and we hope you will. If you live in the Eastern or Central time zones, call us, and you can get in queue, and we'll get to calls throughout the program, 202-748-8900. If you live in the Mountain or Pacific time zones, 202-748-8901. And you can send us a tweet. We love mixing tweets in throughout the program. If you tweet us at C-SPAN, use the hashtag landmark cases so we can see it and mix your comment in. So 1971, the Vietnam War was beginning to falter for the United States. There were 156,800 soldiers in Vietnam, down from a high of 334,500 just 1 year earlier. There were 2,357 U.S. deaths in 1971, down from 6,081 in 1970. And back here on the home front, the war's popularity was certainly diminishing. We're going to move on to the cast of characters, as we call them in this case, starting with the Pentagon Papers themselves. What were the Pentagon Papers?
Secretary Robert McNamara, Defense Secretary, had the idea, as the war got worse and worse with the fewer and fewer ways out, it seemed, to commission a study, a historical study. How did we become involved in the war? What happened? Who did what? Why were we there? One might think you would do that study before you entered a war, but we had not done that. And so Secretary McNamara commissioned that study, got together within the Defense Department scholars and others to use highly classified Defense Department documents to prepare a study of how we became involved, going back to World War II and thereafter, and all the way to 1968 when the Pentagon Papers ended.
Why did the government want to keep the Pentagon Papers secret?
Well, it was interesting because this was the Nixon administration that was in charge at the time that this litigation was brought. Most of the material in the Pentagon Papers was embarrassing and harmful to previous administrations because, as Floyd said, this study went back to the Truman administration, back to the end of the Second World War, and it was particularly embarrassing to President Johnson. And maybe to a certain degree to President Kennedy. So the Nixon administration wasn't so badly embarrassed by the contents of the material that was indicated that the government had lied to the American people, had done various different things that were quite damaging. But the Nixon administration became convinced, in part because Secretary Kissinger made particularly strong arguments, that if you don't stop this, if you don't stop these leaks, where is it going to stop? And you've got to be able to stop this kind of broad-scale leaking of classified, dangerous information, or there's no stopping point. And we will have no credibility in the rest of the world about our ability to keep secrets if we can't keep this secret. This was 7,000 pages of material.
Well, you mentioned President Nixon, of course, another character in our story tonight. What should people, especially those who weren't alive, know about his relationship with the press as we get into this case?
Well, Floyd, of course, knows much more about this than I do, but I think everybody who lived during that period or anyone who's studied it knows that President Nixon was not a fan of the press.
You could say. And
vice versa, right? Yeah. So he didn't like the press because they'd been critical of him. They'd portrayed him in ways in which he did not like, and he was very concerned about his vulnerability to the press, and so this was a hostile, difficult, tortured relationship that he already had with the press. So something like this comes along, and he sees that they're publishing secret information, and that might be something else next. He's going to react to do whatever he can to stop it.
I'm going to ask you, Floyd Abrams, to give people a sense of what the New York Times and the Washington Post, the two petitioners in this case, were like in 1971. Very different media landscape than we're experiencing today.
Yes, there were newspapers then, and only newspapers and 3 television networks were the heart of the information givers in the country. There were local newspapers around the country, very often one newspaper in a town or one newspaper in a city, sometimes just a few newspapers in a state. Newspapers were the primary place most people got their news. And as I indicated earlier, 3 television networks, NBC, CBS, and ABC. And from those sources, the great bulk of the information came to the public. And of course, the world is very different now.
This is our first case in this series with Warren Burger as Chief Justice. What should people know about him?
Well, people should know that, in the first place, this court that decided this case, there were 5 of the justices who had been appointed by Republicans. Chief Justice Burger had taken over the Supreme Court, appointed to the Supreme Court by President Nixon, and was a very different person than his predecessor, Earl Warren. The Earl Warren Court was quite famous for protecting civil liberties and opening new areas of individual rights and so forth. The Burger Court, Chief Justice Burger, Warren Burger, who had been from Minnesota and had served on the Court of Appeals for the District of Columbia Circuit, was very interested in the orderly processing of judicial decisions, the structure of the court, how decisions got made, how state courts worked, and that sort of thing. He was a much more businesslike jurist than his predecessor, Earl Warren.
Floyd Abrams, there would not be a Pentagon Papers case without Daniel Ellsberg. Who was he?
Daniel Ellsberg had been a Marine in the war in Vietnam. He was an intellectual. He had favored the war in its early days and had come to believe that it was a war crime. He had come to believe that we were doing things in Vietnam which violated international law and principles of morality and the like. He was one of the authors of the Pentagon Papers. He was a scholar as well as everything else I've said. And so he was one of the authors commissioned to write chapters of the Pentagon Papers. And he came to the view that if only the public could see the degree to which it had been lied to through the years, which perpetuated American presence in Vietnam, that they would demand that the war end. He felt, notwithstanding our victory and notwithstanding everything else that happened, and he feels today that he failed, that his motive for releasing this information, for risking jail to himself for a very long time, was to end the war. And while the publication was very newsworthy and it affected public opinion, it did not do that.
We have said that this is a very accelerated case, and some of the cases in this series have taken years to get to Supreme Court. Not so in this instance. Let me walk you through this very quick timeline that this case was under. Just a bit prior to the June 13th, 1971 publication of the first story, the newspaper had gotten the material from Daniel Ellsberg. By June 15th, the Times received its cease and desist order. The government seeks a restraining order. Then June 18th, the Washington Post published its first story on the Pentagon Papers. By June 19th, the Second Circuit Court of Appeals rejected the injunction. On June 22nd, the Second Circuit Court of Appeals hears cases and grants the injunction. I don't think that's correct. There was two different courts in this. On June 25th, Supreme Court takes up the case. The oral arguments were heard on June 26th. Here's another interesting thing we'll talk about later. On June 29th, the United States Senator from Alaska, Mike Gravel, entered the papers into the Senate record through his subcommittee, and the court announced a decision by June 30th. So very rapid discussion in the legal system of this case, and we'll learn about the implications of that as we go forward. First bit of video, we're going to introduce you to Hedrick Smith. He was a longtime New York Times reporter and happened to be one of the New York Times reporters that was writing this story. He talked to us very recently, and he told us how the New York Times got the information and how the paper conducted its work to publish that first story.
I first saw the papers in the Hilton Hotel on 6th Avenue in New York. Sheehan had gotten a hotel room there up in about the 35th floor. We had two file cabinets that were absolutely full of papers. So we're talking about 4 drawers, 8 drawers of papers. I mean, tens of thousands of pages of documents. We just started to go through them. Sheehan had just begun looking at them by the time I got there. And it was just amazing to see the amount of material and to look at one document after another, top secret, top secret, top secret, eyes only, which means only the president can see it, or the Secretary of State, or the ambassador, or the commander, or the Joint Chiefs of Staff, whatever. And we started to go pouring through them to try to figure out how to do stories about them. I mean, there was so much material, it was almost impossible to figure out how to handle it journalistically. What we did was we simply followed the organization of the Pentagon Papers. We took 13 chapters and spread them out and basically dealt with them in that way. I think in the end we came out with 12 or 13 different days on which we ran the papers. The government's argument was that publishing the papers would harm national security. We looked at it. This was history. All these events were over. We're talking about the Eisenhower years, the 1950s, the Kennedy years, the 1960s, and then the Johnson years, the late 1960s. And here we are in 1971. There was only one part of the Pentagon Papers that was live in the sense that events were still unfolding, and that was what was called the diplomatic annex. It was all about the various different efforts and peace channels there were to negotiate some kind of settlement between Washington and Hanoi. We never touched that. We took one look at that. We said, if we write about that, we have no idea whether or not those channels are still alive. We could harm diplomacy. We're not going to go into that. So we were mindful of actual national security needs.
And let me show you the headline that came out of that work. It was June 13th, 1971. Vietnam Archive Pentagon study traces 3 decades of growing U.S. involvement. Neil Sheehan had the byline for that story. Was there an immediate reaction in the country to this first story?
It's something that grew. It was a page 1 story. It was a big story. It was clear that it was a big story. The Times, incidentally, did not publish the entirety of the rest of the Pentagon Papers. They spent 3 months editing them to decide what was newsworthy and what would hurt national security beyond the one chapter that Rick Smith talked about. But it was a big deal from the moment it started to be published, and it was not surprising that the administration reacted strongly to it. The question was, would they do anything about it, or would they simply condemn the Times? As you mentioned earlier, relations between the press, the Times in particular, and the Nixon administration were hostile. And so one possibility could have been simply to minimize it, which one might do if one was afraid of national security secrets being revealed, to minimize it and denounce the Times. That's not the way the administration decided to go.
The Nixon administration, President Nixon, created a historical treasure trove for the country by taping his Oval Office conversations. We're going to let you listen to a portion of two of them, one on June 13th between Alexander Haig and Richard Nixon, and then right after that, Henry Kissinger and Richard Nixon talking about the New York Times and how the administration should respond.
Anything else of interest in the world?
Yes, sir. Very significant, this goddamn New York Times expose of the most highly classified documents of the war.
Oh, that. I see. I didn't read the story, but you mean that was leaked out of the Pentagon?
Sir, the whole study that was done for McNamara and then carried on after McNamara left by Clifford and the peaceniks over there. This is a devastating security breach of the greatest magnitude of anything I've ever seen.
Well, what's being done about it then? I mean, I didn't. Did we know this was coming out?
No, we did not, sir.
We're putting them on notice that they're violating a statute because we have a communication from Mel Laird as to the nature of the documents, and they fall within a statute now.
Right.
I know whether you've been noticed it, but this thing was Mel was working.
Henry's on the other. He just walked in. I'll put him on the other line. Go ahead.
Mel had a pretty good go up there before the committee today on it, and it's all over town and all over everything, and I think we'd look a little silly if we just didn't take this low-key action of advising them about the publication.
Did Mel take a fairly hard line on it?
Yes, he gave a legal opinion, and it was a violation of the law, which of course puts us up where we have to get.
Well, look. As far as the Times is concerned, hell, they're our enemies. I think we just ought to do it. And anyway, Henry, tell them what you just heard from Rostow.
Well, Rostow called on behalf of Johnson, and he said that it is Johnson's strong view that this is an attack on the whole integrity of government. That if whole file cabinets can be stolen and then made available to the press, you can't have orderly government anymore.
So we're looking at it through the lens of history, but I want to hear what both of you have to say about listening to those conversations unfold and the urgency with which they were bringing this matter to the president. Floyd Abrams, we'll start with you.
First, it's just wonderful to hear it. I mean, it's just marvelous.
I've never like those words, the goddamn New York Times.
Yeah, yes, and they're our enemy. That must ring true today. My reaction is that that's a pretty loose way to make a decision. That's a pretty unthoughtful, unserious way to make a decision to go to court and at least implicate very strong First Amendment values.
Ted Olson, you've been on the government side and thinking about whether or not to litigate. So what's your reaction?
Well, I do think that this was regarded by lots of people, and legitimately, as very, very serious. These were all documents that were, not all of them, but many of them, marked top secret. The government had decided that these were very sensitive documents. When that classification is applied to a document or a record, it means that the government has determined, responsible people in the government have determined that it would be very dangerous to the United States, the security of the United States, if that information were shared publicly or leaked out. So, on the one hand, I understand what Floyd is saying, and don't necessarily disagree with him, but they were concerned this was a massive breach of national security. When you have this magnitude of top secret materials, and they knew at that point that some of it had come out in the New York Times, but they also thought that they also knew this was probably just the small tip of the iceberg. There was a lot more, and they weren't even sure at that point how much more was yet to come, and where was it coming from.
And I think the last thing Ted said is a very important point. They were never very sure, even though we told them during the case effectively what documents the New York Times had. It should be said that of the 7,000 pages, 3,000 were copies of the New York Times and other newspapers, duly stamped top secret, one page after another. The other 4,000 pages all ended as of 1968, 3 years before this all began. They were designated, as Ted said, top secret. Indeed, the way the government works now as then is that if any one document out of a series of documents has a higher designation, everything is ranked at the higher designation. So I don't think, or I think I know, they didn't know what was in the Pentagon Papers. And looking back on it, we do know what was in it. And while there were some things, most of which the New York Times did not publish, having spent 3 months pruning it to decide what could harm national security, we do know that, you know, a lot of time has passed. We haven't seen an article since then saying, look, now we know, look what happened. Look at the terrible things that have happened as a result of publication. I wrote an article 10 years after the Pentagon Papers came out in which I interviewed all the participants who would talk to me to ask me what happened. And none of them could cite anything harmful.
43 volumes and over 7,000 pages of material in the Pentagon Papers. So when the New York Times published, quickly went on to the Washington Post, as we saw, a story that was depicted in Steven Spielberg's movie. We're going to show you the headline that came out on June 18th in the Washington Post. Very similar documents reveal U.S. effort in 1954 to delay Viet election is their first story. We're going to return to Hedrick Smith on other papers publishing the Pentagon Papers. Let's listen.
When Ellsberg was smart enough to go to the Washington Post and then the St. Louis Post-Dispatch and then the Chicago Tribune and other papers to keep getting other papers to print more of the Pentagon Papers to show the government that it couldn't stop the publication, we'd broken the dam. The other papers knew that they were not going to get thrown in jail. They were not going to get accused of treason.
But this is a self-governing country. The Constitution provides for a separation of powers.
What on earth are you doing?
Courts enforcing the press, overseeing all the branches of government relying on very well.
They all followed your lead and published the papers.
At least we're not alone.
I have to tell the audience, just a small eye roll here because the New York Times was the first to publish the papers, but that's drama after all. I wanted to ask both of you from a legal strategy standpoint, Daniel Ellsberg, sending it out to so many papers, how does that change the government's ability to prosecute the case?
Well, Floyd should be the one to answer that first because he was directly involved.
Right.
Well, it did make it harder to prosecute the prior restraint case, the case that we've been talking about against the Times and then other papers. They did bring actions against the Post and the Christian Science Monitor and other papers, who got the papers from Ellsberg to stop them as well. But one judge in the District of Columbia Court of Appeals put it very well when lawyers were in front of him on this case. And he said, you're asking us to try to stop a swarm of bees from publishing material. There were so many entities publishing them so quickly that the idea of herding, he said, this so that everyone could be enjoined was getting to be impossible. And I think that had an impact, a real impact on the Supreme Court, because if they can't effectively limit publication, what's the point of doing it?
Daniel Ellsberg understood the concept of going viral before we got to it today.
Well, absolutely, and that is a situation, and Floyd was there, knows, but once this genie was out of the bottle, and it was showing up everywhere. And you went through the timeline for the court. The Supreme Court of the United States had very little time to know what they were doing. The justices repeatedly said, "We don't know what we're dealing with. We don't know what the facts are. We haven't had time." In fact, one or more of the justices, in the dissenting opinion, was quite critical of the New York Times, saying, "Well, you had 3 months to look at this and to decide what you wanted to publish, and you're giving us no time at a couple of days or less than that." The briefs, as Floyd, I think, already said, some of the briefs were filed the same day as the oral argument in the United States Supreme Court. So the justices were frustrated because they didn't have time, but they were also realists because they knew that all this stuff was happening. Ellsberg had put it out everywhere, and what could they do with the judicial decree to stop something from happening that was already happening? They resorted to the fact that, well, you maybe can prosecute these people, but we really can't stop them from these documents or this material from being out in the public because it's already out there.
In our next segment, we'll learn about the case at the Supreme Court, but it's time for some of your phone calls. Let's hear first from Peter in Elizabethtown, Pennsylvania. Hi, Peter.
Oh, hello, and thank you, Ms. Swain. And I have to say a quick congratulations. The Landmark Cases series is just so good. It's pure gold. Thank you. Now, to your excellent guests, this case is so fascinating. I apologize if this is sort of a stupid question. While I have no doubt that the Pentagon and other agencies abuse their classification powers, trying to keep secrets that would in no way have an impact on our national security or our servicemen. And I think this ruling was very beneficial, a great thing for our nation. I've never quite understood, weren't there copyright laws back in the early 70s? These documents were taken from the Rand Corporation. Didn't the Rand Corporation and possibly the Pentagon have recourse to say, this is our intellectual property? We've been working on this report for years. We'll decide to publish it, and you can't sell your newspapers by publishing our property. Again, I'm sorry if that's a stupid question.
No, it's not stupid at all, and it's a very interesting area. In fact, the papers belong to the United States of America, and there is a statute which says that the United States does not have copyright rights over papers. So fortunately for us, that was not an issue. I'll add that the Solicitor General of the United States, in his arguments for the government against the Times, cited copyright law in just the way you just did. And he said, in effect, look, if we had a copyright on this, we could ban it. This is worse than that. These are national security documents. Surely we ought to have the power to limit those documents from coming out for that reason.
Well, there's one more point to add to that. I think that is a very good question, because in the arguments in the Supreme Court, and one of the justices or more of them said about the New York Times, you've copyrighted your article. You intend to prevent other people from using the stuff that you've copyrighted, so you want to have a prior restraint on somebody else taking your material as under the copyright laws, and yet you deny that same right to the United States. It was a very interesting point.
Next is Stephen in Washington, D.C.
Oh, hello. What an honor. Wow. So great to talk to you. I admire and respect all three of you very much. I was wondering whether and to what degree the sharing of intelligence information has sort of been institutionalized between the media and various administrations and intelligence communities.
You want to do that, Ted?
Well, it certainly has, and we've seen that in the last few years in abundant detail. I mean, there are massive leaks of information. Some of it, we all know about the WikiLeaks and the 2016 presidential election. And there is this symbiotic relationship between the press and the people that get this in, Snowden and so forth. But Floyd and I were talking before we came on the show. Floyd came up with some very, very important affidavits that showed that it was happening and has happened for a long time. And he showed the court that there's this culture in Washington that involves the leaking of classified information to suit the government's purposes in various different contexts. Floyd can explain this better than I can, but the same thing that we're talking about today, in much greater volume, was happening then.
Yeah. Yes, and that was more, as the questioner quite rightly used the word, it was almost institutionalized in that sense. A small group of journalists trained in this area worked very closely with and received leaks from people in the government who wanted certain information out for some reasons. Some to promote national security, some to make sure that the Army got more money than the Air Force, some to make sure that so-and-so didn't get credit for something when they wanted someone else to get credit. That still exists. But at this time, and there was a brilliant affidavit by Max Frankel, formerly the executive editor of New York Times, which I really recommend to you all, outlining how the system almost of mutual benefit by leakage existed at that time.
Rick is up next, Louisville, Ohio.
Yeah, hey guys. In the last 20 years, I've had 3 books published. And I grew up in Detroit back in the 60s and the 70s. We were the greatest country in the history of mankind. We had laws in place. We had trade laws, tax laws, banking laws, antitrust laws. But the most precious of all laws were the laws that were created by the greatest generation that basically regulated the media, fairness doctrine, and whatever. And you know, you're talking about Vietnam. Vietnam was started by Lyndon Johnson. Lyndon Johnson was a Texan. The last 5 wars have been started by Texans. We've been at war for 20 years. Clear Channel Radio had 1,500 AM radio stations during the Bush administration. AT&T comes out of the state of Texas. Georgia has CNN and Time Warner loaded with military bases. The East Coast, Connecticut, in New York and California, that's your liberals, loaded with the Wall Street, loaded with the Treasury and the Federal Reserve and Silicon Valley.
Rick, I'm going to jump in because you're really taking us in a much broader sense than the case. So thanks for your call. Our time is short, so with apologies, I'm going to move on to John in Westlake Village, California. Go ahead, please.
Yeah, my question is, the model that's being proposed is this American model arising in the American Constitution. My question is, the British, they have a prior restraint law, they have a state secrets law, they have very strict libel laws. They seem to have a pretty rigorous, fair press, maybe even better than ours. Why is the model that Mr. Abrams proposing better than the other model?
Thank you.
Well, first, I really don't agree that they have a better press or have had for many years a better press than we do. That's a judgment call. Second, when British editors want to publish something, they come here. That's what happened with the Snowden materials, that they were released through an American subsidiary of The Guardian. And British journalists are very envious indeed of the free press that we have. More broadly, yes, there are different ways for democratic societies to be organized, and in terms of striking balances between freedom and liberty and other important interests. We lean very heavily in the direction of more freedom of the press, more freedom of speech. I think that's a good idea, but there are other ways to run legal systems and other ways. Canada is more restrictive than we are. I prefer our system, and when you read our cases, I think they're really very powerful.
On to the court in 1971. As we said, Chief Justice Warren Burger, and we're going to tell you about the other members of the court. The Nixon appointees were Justice Burger, Chief Burger, and Harry Blackmun. The Johnson appointees, Thurgood Marshall. Kennedy appointees, Byron Whizzer White. Eisenhower appointees still on the court in 71. John Marshall Harlan II, William Brennan, and Potter Stewart. And Hugo Black and William O. Douglas, Roosevelt appointees, made up the 9. The case was heard on June 26, 1971, just 13 days after the New York Times published that first article. There were 2 hours of oral arguments, and we're going to listen to a little bit. But you didn't argue the case. Tell me about how the legal team was assembled and what the decision was on the argument.
Well, the chief counsel for the New York Times was Professor Alexander Bickel from the Yale Law School. Professor Bickel, under whom I studied at law school, was viewed in the language of those days as a conservative academic. He had clerked for Justice Frankfurter. He was, as he once put it to me, not a First Amendment voluptuary. And he was not. And indeed, if there was any criticism of the Times' lawyers' presentations to the court at every level, made then and even now, it was that we didn't talk enough about the First Amendment. We talked about separation of powers. We talked about statutes. We talked about a lot of things which we thought might be easier to attract the votes of conservative jurists on the court.
We're going to listen to a portion of Alexander Bickel's argument before the Supreme Court.
Let me give you a hypothetical case. Let us assume that when the members of the court go back and open up this sealed record, we find something there that absolutely convinces us that its disclosure would result in the sentencing to death of 100 young men whose only offense had been that they were 19 years old and had low draft numbers. What should we do?
Mr. Justice, I wish there were a statute that covered. You're posing me a case, of course, Mr. Justice, in which that element of my attempted definition, which refers to the chain of causation.
I suppose in the great big global picture, this is this is not a national threat. There are at least 25 Americans killed in Vietnam every week these days.
No, sir, but I meant it's a case in which the chain of causation between the act of publication and the feared event, the death of these 100 young men, is obvious, direct, immediate.
That's what I'm assuming in my hypothetical case.
I can only say as to that it is a case in which, in the absence of a statute, I suppose, most of us would say...
you would say the Constitution requires that it be published and that these men die. Is that it?
No, I'm afraid I'm afraid that the inclinations of humanity overcome a somewhat more abstract devotion to the First Amendment in a case of that sort.
So help us understand this hypothetical. What was the justice getting at there?
Well, the justice was saying, I want you to assume that as a direct result of publication of the Pentagon Papers, 100 young men are going to get killed. Right. Are you telling me that the First Amendment requires that we allow that to be published? And now, this was Professor Bickel's first argument anywhere. This was his first case and his first argument in the Supreme Court. The first thing he did was what great advocates like Ted will do sometimes, which is not quite to answer the question, to try to bring the justice a little bit away from it. Justice Stewart would have none of that. He insisted on a direct answer to the question, and Professor Bickel gave what he considered, and I considered, the most essential, critical, and needed answer, which was yes, in that situation, a prior restraint would be consistent with the First Amendment. That was a controversial answer, The American Civil Liberties Union the next day filed a brief in the court denouncing that answer, a very rare thing in Supreme Court practice, but it was one that he thought was essential to win over or keep the votes of the two members of the court, Justice Stewart and Justice White, that we thought we needed the most.
One of our viewers, Joe Paulson, writes that this bit sounds like a gotcha, but not sure where to draw that line. What if the article saved the lives of thousands of people, but in the process a limited number would die somehow? Just a comment.
So, well, he's right. This is a gotcha kind of a question. It is the kind of hypothetical questions that justices ask, not to embarrass the advocates, but to probe where the limits are. And those are these kind of questions that advocates have to deal with in the Supreme Court, and there's usually no perfect answer. You are talking to 9 different Supreme Courts. It's not one Supreme Court. And as Floyd said, what he had to do was to be mindful of the fact that he had a certain number of votes that he was probably not going to lose. He had a certain number of votes that he was probably not going to win. And Justice Stewart and Justice White were the two that he needed. Well, he needed one of the two or both of the two, if he could, to win the case. And so what he was doing, and for someone who had not argued in the Supreme Court before, I agree with Floyd. This was a very adroit and careful answer, because what he did is he gave a reasonable answer, he preserved his position, he didn't lose a vote that he might otherwise have lost if he'd taken a categorical position that, yes, this is an absolute thing under the First Amendment.
I'm going to have to jump in just because of time. I want to get Erwin Griswold's argument on into our program here, who was the U.S. Solicitor General, a position that Ted Olson later held. You should know that he was nominated by LBJ to that position, and President Nixon kept him on. Let's listen to some of his argument.
But I also think the heart of our case is that the publication of the material specified in my closed brief will, as I have tried to argue materially affect the security of the United States. It will affect lives. It will affect the process of the termination of the war. It will affect the process of recovering prisoners of war. I cannot say that the termination of the war or recovering prisoners of war is something which has an immediate effect on the security of the United States. I say that it has such an effect on the security of the United States that it ought to be the basis of an injunction in this case.
Ted Olson, you've been in that role. What was he saying?
Yeah, well, what he was saying is, I am speaking on behalf of the United States. I am telling you, based upon the material that we have in the possession of the United States, that the publication of this material will damage the United States in various different intangible ways. I can't say that it will have this specific result immediately, but this is dangerous material. We have a responsibility to protect the United States and protect the citizens of the United States, and I'm telling you, to the Supreme Court, don't let this happen, because it will cause great harm. So he's really putting it to them at that point.
And that's a very strong argument to make, even if it isn't much supported, I don't want to say by the facts, but even if he can't cite much in support of it. And this is what the United States was saying from the moment the cases began. The word that they kept using was irreparable harm to the United States. Their problem was when they got in front of judges who asked them hard questions, sort of, where's the thing? Give me a document. Show me a document which will really do great harm. They could not do it.
Before we get on to the court's 6-3 decision, we have to get one more step in this, which we said at the outside. Wild and Wonderful on Twitter reminds us, additionally, the papers were entered into the record of the Senate by Senator Mike Gravel. So what happens when we bring the record of the United States Congress into this? Floyd Abrams, what did that do to the information?
Well, first, we don't know what effect, if any, it had on the court. We don't even know if the court knew it. It
Who pays attention to the congressional record, right?
Yeah,
I'm just kidding.
I mean, it obviously is a very strong argument against a prior restraint. What's the point? Well, what are we doing? Why are we issuing court orders, which at least enormously implicate the First Amendment, if nothing's going to be served, if everything is out already? And so, to the extent that the Gravel papers, as they became known, had, if the court thought about them, if they knew it was everything, and bearing in mind that, of course, the theory of this is the enemy will learn things from it, then it could have had an impact. I haven't read anything from anybody, though, in all the literature and memoirs indicating that it did.
Hypothetically, though, it could have.
It could have.
It could have set up another challenge of branches of government, the Congress against the administration.
Well, yes, except that there are another provisions in the Constitution called the Speech or Debate Clause, which pretty much insulates members of Congress from any liability for what they might put in the congressional record.
So we're moving on to the decision, but first, a couple more calls. Josh, I'll go to Iowa. What's your question?
Good evening. My question is on Justice Black. He was famous for his First Amendment absolutism. How influential was he in this decision?
Okay. If you'll hold on just a second, we're going to actually put some of Justice Black's concurrence on the screen. So thanks for that question. We'll get to it in 5 minutes. James, Caliente, California. Go ahead, please. Hi, James.
With the internet today and the ability to just disseminate information instantaneously, the whole concept almost seems archaic. I mean, people can be punished after the fact, and that may be the only way that people, and then people will stop publishing, but somebody's still going to do it. In the age of suicide bombers, people will certainly risk their lives getting material out there. I just think this case looks interesting from a different age almost now, and it's not that long ago, but it was a different time.
Thank you very much. Is prior restraint archaic?
Well, no, because not there are different cases, different facts, different things published, but the questioner has a very serious and valid point, to which I would only add that we're talking in this case about 7,000 pages, the largest leak in American history. Edward Snowden took millions of pages, if you count it page by page, in terms of what he had access to. We are so far gone from those days in that sense that, yes, it may seem a little bit archaic. What's the same, though, is that things occur where presidents don't want, either because of national security concerns, personal political concerns, or whatever, don't want certain things published. And the effect, I would say, of the Pentagon Papers case is that what they have assimilated from their advisors about the case is that they can't keep it from being published. But it's recent that presidents have called in the editor of the New York Times, the publisher of the New York Times, said, don't publish the fact that we're not getting warrants for certain overhears within the country. And the Times in that case said no.
Here is the ABC News report on June 30th, 1971, when the case was decided.
For 2.5 weeks, two constitutional principles have clashed. The government's view of our national security versus the newspapers' view of their freedom to print. And the newspapers won. From the Supreme Court where the issue was decided, here is ABC's Bill Zimmerman.
A dramatic 4 minutes late, the justices sat for the business at hand, 8 of them with Chief Justice Warren Burger reading the 6-3 decision in which he was among the dissenters. The opinion quoted from a 1963 case. Any system of prior restraints of expression comes to this court bearing a heavy presumption against its constitutional validity.
And here's how those decisions turned out. The 6 concurrences was a per curiam decision, speaking on the voice of the court. But there were, as Ted Olson said, 9 different opinions, really, out of this case. 6 concurrences. Justice Black, joined by Douglas. Douglas, joined by Black. Brennan, Stewart. Stewart's was joined by White, and White joined by Stewart and Marshall, if you can follow all that. 3 dissents, the Chief Justice, and Harlan, who were joined by Berger and Blackmun. Okay, we're going to go through a couple of the very brief texts of the decisions, the opinions. First, the per curiam. Any system of prior restraints of expression comes to this court bearing a heavy presumption against its constitutional validity. The government thus carries a heavy burden of showing justification for the imposition of such a restraint. The district court and the Court of Appeals held that the government had not met that burden. We agree. Then we had that question about Justice Black and his concurrence. Here's some of what he said. Paramount among the responsibilities of a free press is the duty to prevent any part of the government from deceiving the people and sending them off to distant lands to die of foreign fevers and foreign shot and shell. In my view, far from deserving condemnation for their courageous reporting, the New York Times and the Washington Post and other newspapers should be commended for serving the purpose that the Founding Fathers saw so clearly. So there's our First Amendment absolutist. What do you think about this decision, what he's written?
I weep with pleasure listening to Justice Black's language. It was his last opinion on the court. It was an opinion he was justifiably very proud of, and it is one of the enduring remains of New York Times versus United States.
I'm going to put 2 of the dissents on the screen and then ask Ted Olson to react. Chief Justice Berger, in this case, the imperative of a free and unfettered press comes into collision with another imperative, the effective functioning of a complex modern government, and specifically the effective exercise of certain constitutional powers of the executive. Only those who view the First Amendment as absolute in all circumstances, a view I respect but reject, can find such a case as this to be simple or easy. And then I'll move on to Justice Harlan. This frenzied train of events took place in the name of the presumption against prior restraints created by the First Amendment. Due regard for the extraordinarily important and difficult questions involved in these litigations should have led the court to shun such a precipitate timetable.
I should say that in addition to Justice Black, who was an absolutist, who said that as you read, the First Amendment, Congress shall make no law abridging the freedom of speech or of the press. He said no law means no law. Justice Douglas also held that view, and so there were 2 of those votes. But to get to the dissenting voices, you heard the justice say this frenzied pace. One of the other dissenting justices said it was a feverish pace. What the court below that was reversed here had said, let's send it back to the district court for an opportunity to look at the various documents that are threatened here, and so that we know what we're doing. So these dissenting justices, in addition to disagreeing somewhat with respect to they agreed that there was a heavy burden with respect to prior restraints, but they also thought that we need to know what's going on. In order for us to do our job, we need to know what risk there is, and at least the government should have a number of days, which is what the Second Circuit had ordered, to look at the documents and make judgments with respect to individual cases. We can't be justices or judges of the damage that could be done here unless we know what we're looking at. And that's not such an unreasonable point of view, except that it clashes with the idea that there shall be no prior restraints, not even a short-term one.
We're going to show you the headlines in the 2 affected newspapers as we listen to a call from Francis in Memphis, Tennessee. Francis, go ahead, please.
Hi, I was wondering what books each of you recommend to read to learn more about the Pentagon Papers, and also what each of you like to read most days. Thank you.
I would say the best thing to read about the Pentagon Papers case is Floyd Abrams' book. The book is Speaking Freely?
Speaking Freely.
Speaking Freely. It is a tremendous analysis of the legal issues and the factual issues, and I reread it just in connection with this program, and that's one of the things that I would strongly recommend. I'm sure you would agree.
I'm so moved. I'm trying to think of how to respond. There's a book called The Papers, something or other, by Professor Rudenstein in New York, a whole book on the Pentagon Papers case, written somewhat more recently than mine. Mine was a lawyer's look, and on the ground, what was happening. But I think if you read either one of them, you'll get a very good sense of it.
Let's listen to how President Nixon and J. Edgar Hoover reacted to the decision.
Edgar? Yep. I wanted to tell you that I was so damn mad when that Supreme Court had to come down. First, I didn't like their decision, but unbelievable, wasn't it?
It was unbelievable.
You know, those clowns we've got on there, I'll tell you, I hope I outlive the bastards.
Well, I hope you do, too.
I mean, politically, too, because we've got to change that court.
There's no question about that whatsoever. I had thought it was a possibility of a 5-4.
Yeah, you know, I thought we ought to get White. What's the matter with him?
I don't, well, of course, Wizard White is an old Kennedy crowd.
Right. But then the other one, no. What in the hell is the matter with Stewart?
Well, Stewart is a very wishy-washy individual. He switches from one side to the other.
Isn't that priceless, being able to hear a president's thoughts? Yeah.
It is.
So, your reaction, both of you?
Well, I will say that it's very predictable listening to various different tapes of Richard Nixon, but if you listen to tapes from Lyndon Johnson and some of the language in his comments about things that were going on, and probably other presidents have felt the same way every time they lose a decision in the Supreme Court. I don't know whether they use the same language, but I suspect that you would hear, if there were more tapes, similar language from other presidents who are disappointed. You've covered some very, very interesting, and are covering some very interesting cases in this series, and presidents don't like to lose anything, particularly in the Supreme Court, when they pretty much know that is the end of the line.
I just add to that the reference to Justice Stewart and Justice White is quite right, that they were the deciding votes. We had 4 votes when we came in, and the question was always, would we get 2 more? And it was Justice Stewart's opinion, which is generally viewed as the opinion of the court, in which he wound up saying that the only circumstance in which a prior restraint could issue in a case like this is where the government proves that the disclosure of the materials would surely result in direct and immediate and irrevocable harm to the nation. That's a tough standard to meet, and he meant it to be.
Well, let's also show you some historic footage from ABC on the reactions by Katharine Graham, Ben Bradley, and Arthur Sulzberger.
My reaction was very simply one of joy, one of delight, and one of now we'll go back to business as normal, getting out the Times. I never really doubted that this day would come and that we'd win, and sometimes it seemed like it was going to be a little longer waiting than I had hoped, but here it is, and we're starting publishing tomorrow.
Are extremely gratified, not only from the point of newspapers, which is not the least of our concerns, but gratified from the point of view of the government, of good government, and from the point of view of the public and the public's right to know, which is what we were concerned with.
We are free to publish what we always were going to publish, which was material which in our mind the public had a right to know and which did no damage to the United States. That was our position when we started printing, and it's our position today.
So, reaction from the involved newspapers. We have 20 minutes left, and in this last part we're going to talk a little bit about what happened to Daniel Ellsberg and what the immediate impact was, and then the larger discussion, which we've already started having, about this tension between the government and its desire to have national security secrets and the public's right to know. So, first of all, with the immediate reaction to this, the papers continued to publish stories, but then what happened? Really, what was the result of all this?
Well, I think it did have an effect on public opinion. Public opinion doesn't always have an effect on public policy. It led to the Freedom of Information Act being passed. That was a major step forward in terms of public information. It helped us, on the dark side, solidify the ever-growing breach between people who hated the press, as President Nixon did, and people who were generally supportive of it on the other side. Did it matter in terms of the war? It's hard to say. Probably not. The Pentagon Papers was 1971. It was years more of fighting, and there was even an irony in that. In that, what's the worst thing that came out of the Pentagon Papers? That we kept fighting the war when people in control knew we couldn't win it, and didn't do anything about it except to continue to fight it.
Well, many people also feel there's a direct link between this case and the reaction in the Nixon administration to what happened here and Watergate. That the concern, the compulsive concern, some of it possibly justified, some of it not. I'm not making a judgment about that, about leaks. Some people feel, and I think with justification, it led to the creation by President Nixon of the plumbers to go into Ellsberg's psychiatrist's office and other places, and the compulsive concern about leaks and so forth led inexorably to what would happen 2 years later with Watergate and the end of the Nixon administration.
We're going to hear a little bit of that next with this bit of Richard Nixon on tape talking about how the administration should respond to Daniel Ellsberg.
But I just say that we've got to keep our eye on the main ball. The main ball's Ellsberg. We got to get this son of a bitch. And you know, I was talking to somebody over here yesterday. I mean, one of the PR types, and they're saying, well, maybe we ought to drop the case if the Supreme Court doesn't sustain and so forth. And I said, hell no. I mean, you can't do that. You can't be in a position of having, as I said this morning, we can't be in a position of ever allowing, just because some guy's going to be a martyr, of allowing a fellow to get away with this kind of wholesale thievery, or otherwise it's going to happen all over the government.
So a legitimate argument that's going to happen all over the government if something doesn't happen. So what happened to Daniel Ellsberg, the leaker?
He went back to his real life. He taught, he wrote.
He was never prosecuted.
He was prosecuted for a time, and nothing came of it. I mean, the prosecution which was brought about the Pentagon Papers was aborted by the fact of the break-in that Ted referred to, which was the break-in commissioned by the President of the United States, which led the Judge Byrne in California, to say this is conduct of such enormous unacceptability, so destructive of the judicial system that this trial can't continue. So in any event, Ellsberg never went to jail, but he should get credit, a lot of credit, for being willing to do something as dangerous to his own safety as this.
What do you think, Tittles?
Well, I everything that Floyd said is correct. On the other hand, I would think that there were a couple other movies that were recently out, including a movie called Dunkirk, and we've seen movies about the landings at Normandy, and that goes back to what they said in the Near case in 1931 about the movement of troops and so forth. The government has got to be able to keep certain secrets. There are secrets with respect to how you construct nuclear weapons. There are secrets about where intelligence is gathered. There are secrets that the United States and other governments, but particularly I'm talking about our government, needs to be able to keep certain secrets. Now, Daniel Ellsberg thought he was right. I thought he was doing the right thing, and I'm not quarreling with that, at least in this context. But we have a system of government of laws and not of men. There's a point at which individuals cannot make these decisions for themselves about what is in the best interest of the national security of the United States. And under some circumstances, prosecutions and other efforts that may be necessary to preserve and protect government secrets have to be something that is a part of the functioning of our government.
Let's go back to calls. Next is Dan, Livingston, New Jersey.
Yes. Hi. Enjoying the show. So my question is, has the case been used as any precedence for any subsequent case? And has it changed anything regarding transparency, regarding, the sunshine laws in the government, and anything regarding the whistleblower protection laws?
Thanks very much.
I think it's yes to all of those. It has certainly led to more transparency. As I mentioned earlier, we wouldn't have a Freedom of Information Act, but for all of what we've been talking about. Has it been cited in other cases? Yes, and indeed in one case, the government for a time was winning. That was under President Carter, in which the Progressive magazine published an article titled How to Build an H-Bomb. And the government went to court under President Carter. The U.S. District Court granted a prior restraint, saying the Pentagon Papers case says it's a very heavy burden. Absolutely. And the government has met it in this case. What happened then was that it was determined that the supposed secrets discussed and revealed in the Progressive case were already known in the literature. And the government dropped the case, and it was over. But the fact that the case is a general barrier to the issuance of prior restraints, even in the national security area, that doesn't mean that it's absolute, and Ted's absolutely right about that. It's been cited in other areas in which judges in the criminal courts were entering prior restraints against publishing information, which is what the law is in England, information about a confession of a defendant before it was admitted into evidence. And the Supreme Court, in the course of striking down that prior restraint, cited the Pentagon Papers case, as other cases have as well.
And there is also the whole area of gag orders in criminal cases where the judge might feel it's necessary to protect the rights of a criminally accused, to tell the press, don't talk about, and to tell the lawyers in connection with the case, don't talk about what's happened in the evidence here, and prejudicial publicity can deprive an individual of his right to a fair trial. That's a different issue, but it's not unrelated.
We talked to constitutional scholar, conservative, Michael Paulson, you might know him, about this case, and he said one thing that it did was it created a gravitational pull. So even if there's a violation of statute, there's hesitancy on the part of the government to pursue. Would you agree with that?
Well, yes and no, but we have seen during previous administrations, I'll talk about previous administrations, a spike in efforts to subpoena newsmen about where their sources are, and efforts to prosecute under certain circumstances. Yes, it has deterred and has had that kind of an effect, but it also leads government to try to figure out, are there other ways in which we can protect secrets, and we can go after potential criminal violations by attempting to find out where this is coming from. The Justice Department has specific rules about this, which they're revising all the time, but that's one of the manifestations of it.
Now, the major impact is in the area of the case itself, and that's prior restraints. It it laid down a really tough barrier to overcome. I mean, if the government can't win a case in the middle of a war at a time when American POWs are being held and the government was representing that publication would irreparably harm the nation, if they can't win that case, it's going to be very hard for them to win any others in this area. But in these other areas that Ted is mentioning, look, we have a functioning government. After all, I mean, it is. We don't live in a society in which anyone can do anything, take anything, release anything, and run no risks for doing so. And that's why Edward Snowden lives in Moscow and not Washington.
To that end, a Twitter follower named Student asks, is the freedom of the press as an originalist matter the freedom of anyone to print or the freedom of one to print anything?
Well, I think to go back to Justices Black and Douglas, the constitutional provision says Congress shall make no law, but there are obvious areas where there are laws that govern and relate to the freedom of the press. It is not just the freedom of press, but it's freedom of speech. And those are very much overlapping, especially in today's world. Freedom of speech and freedom of the press, and in who's a journalist and who can publish what. Those are very, very blurry lines, and there are all sorts of litigation that come out of the fact that it's very difficult to distinguish in some ways.
And in some ways, it's meaning less and less, which is to say, given social media, we live in a world now in which we're not asking anymore, all the time anyway, are you a journalist or not? You have information, you want to talk about it, you either have a right or you don't have a right, and you generally do have a right to talk about it. Anyone can generally spout off about just about anything he wants, but not everything. And when we're in the tiny area of the not everything, how to build an H-bomb, if no one knew, then it wouldn't matter if you were a journalist or not. You wouldn't be allowed to do it, and you would go to jail if there were prosecution for it.
On Twitter, EP West Virginia Law says of Daniel Ellsberg, and yet Ellsberg also demonstrated respect for the law when he turned himself in. I've never thought that his decision to disclose the Pentagon Papers was an easy decision for him to make. And I just actually listened to a very recent interview where he underscored that he thinks of himself as a patriot throughout this whole process.
He does. It should also be said, Ellsberg did not turn over to the Times the entirety of the Pentagon Papers. He kept what were called the negotiating volumes, which is to say volumes of the Pentagon Papers as they existed in 1968, relating to efforts to negotiate a way out of Vietnam, because he wanted the war to end in Vietnam and did not want to frustrate those efforts. So the Times didn't have everything. It didn't publish everything it had, but Ellsberg didn't give them everything also.
Maybe it's a little bit of a devil's advocacy, but everybody who does something like this, every whistleblower, every person who leaks information thinks of themselves as a patriot. They're doing it because they think it's right, they think it's a better good, is a person. And so you have to have the discussion at least of whether or not you have a legitimate government elected by the people, subject to laws and subject to the Constitution. Can an individual decide it's better for me to do something to try to stop the war than to behave according to what the laws are with respect to government secrets and restraint? It's not as one-sided as the person who does the leaking thinks, I did it because it's in the best interest of my country.
No, that's true. And it's not, it is a part of what is usually civil disobedience. I mean, usually the people that do this are willing, if necessary, to pay the price for doing it. And there are people who have done it. I mean, I've been very critical of WikiLeaks and of Mr. Snowden and with some of his revelations. And I'm not alone in that. So it's not that one can't pass judgment. It's not even that everybody who acts on his own conscience therefore ought to be absolved from the consequences. But some people who do, I count Ellsberg as one, are worthy of praise for doing it.
We've been referencing them. Let me just get them on for the record. Some of the more notable cases in the past decade or so. The Valerie Plame case in 2003 and 2004. The Washington Post reporting on military black site prisons in 2005. Chelsea Manning's leaking of the U.S. diplomatic cables in 2010. And the Edward Snowden leaks on national security documents in 2013. One of our viewers, Joe Paulson, writes, I'm worried about the ability to release volume of material that makes the Pentagon Papers look like a trickle at a moment's notice. You referred to this before. By a download by some low-level government employee. WikiLeaks level leaks worry me. I thought Chelsea Manning was rightly prosecuted.
Well, that's the problem. And Ellsberg was worked for the Rand Corporation, or was the government contractor. Snowden, and so forth. People work for government contracts are not even working for the government. We allow, in this age of computers and the internet and so forth, vast amounts of information to be accessible to individuals, some people at very, very low levels in government who aren't being watched properly or aren't being supervised properly or aren't being trained properly or who haven't been checked out properly. And some of the times when you see these things happen, these are individuals that maybe if people were paying more attention, they could have prevented these people from having access to lots and lots of potentially dangerous information.
You talk about Manning? Well, we're talking about a private?
Yeah.
A private in the Army with that sort of access? I agree.
We have 3 minutes left. One other thing to get on the record is Erwin Griswold, who was the Solicitor General at the time. In 1989, he published an op-ed in the Washington Post called Secrets Not Worth Keeping, the Courts and Classified Information, where he said he was on the wrong side of history in this argument here. So we have time for one more call. It's going to be John from League City, Texas. John, you're on. Welcome.
Thank you for taking my question. With regard to the standard of prior consent and its application with regard to the Pentagon Papers, how would that have been legally different had the conflict in Vietnam been a declared war rather than an executive military action whose constitutional basis was more nebulous?
It would not have, if all you did was to read the opinion, you would think it would have no effect, because the opinion was not based on the proposition that it was simply executive action. But I agree with the thrust of your question. I think if this were a situation of a declared war, I'll go farther, a popular declared war. If this were World War II redone and somebody started leaking information saying that I know better than the government, he wouldn't have a lot of friends around, let alone, I would also add, that the press would not publish a lot of that sort of information for the same reasons that the Times didn't publish a good body of information that it had and chose not to print in the Pentagon Papers.
You have a thought on that?
No, I agree with what Floyd said.
So we have 2 minutes left. I'm going to ask each of you to kind of put a wrapper on this for our audience. In the context of the complex media environment in which we live today, what is the meaning of the Pentagon Papers case? What's the import of it for our society? You want to start, Ted Olson?
Well, I think that it will always remain a precedent of the United States Supreme Court that the First Amendment, the one thing that the First Amendment protects is the ability to speak or to publish, except in extreme circumstances. There are ways in which speech and the press can be constrained with respect to libel or with respect to copyright or with respect to various different things, but generally speaking, telling someone that they can't speak, censoring speech, is something that the courts are going to look at with great skepticism.
I agree with all of that. I'd simply add that I think that the lesson, the impact of the case on American presidents has been to persuade them their advisors and the like, that when somebody wants to print something, the president can't stop it. The presidents aren't going to go to court. Presidents don't go to court. Even when presidents feel strongly that information should not be published. That doesn't mean that you can't have such a case, but it says something, that the only case since 1971, when the Pentagon Papers was decided, was about the H-bomb, no less, and we haven't had one since. So that's almost a non-weapon now of the presidency because of the Pentagon Papers case.
Well, because you worked inside two administrations, what are your thoughts on this restraint on the presidency?
Well, I think that presidents are always frustrated with what the press does and what the press says and what the press doesn't say. And presidents always feel, and I worked with President George W. Bush in the administration at the time of 9/11, and he and his people around him were determined we must not let that happen again, and that those kind of policies may have led to certain decisions that some people feel were wrong, but presidents will be motivated by their need, their perceived need, to protect the citizens of the United States from violence, terrorism, and to protect the security and independence of all of our citizens.
As we close, thanks to our partners at the National Constitution Center for their help in producing this series. Thank you, Floyd Abrams. Thank you, Ted Olson, for giving our audience the benefit of this really interesting discussion tonight on the press freedom and the First Amendment. We appreciate you being here.
Thank you.
Thanks for you being in the audience tonight, and we'll see you for our next landmark case.